When driving on any road, it's crucial for individuals to be aware of the laws that govern their conduct. One of the most significant, yet often misunderstood, is New York's Implied Consent Law. This law has far-reaching implications for anyone who gets behind the wheel and could profoundly affect you if you are charged with a DWI. Understanding the ins and outs of the implied consent law is vital. It not only helps you make informed decisions if you are ever suspected of DWI, but it also prepares you to handle the legal challenges that could arise from a refusal to take the chemical test. Experienced Long Island DWI attorney Jason Bassett discusses the implied consent law. The implied consent law in New York is a legal statute that requires motorists within the state to consent to sobriety testing if they are arrested on suspicion of driving while intoxicated, DWI, or driving under the influence, DUI. Under this law, the act of operating a vehicle while on a public road serves as implied consent to submit to a chemical test to determine the driver's blood alcohol content, BAC, level. When does the implied consent law apply in New York? If you are operating a motor vehicle in New York, you have implicitly agreed to abide by the state's implied consent law. Implied consent in DWI investigations. Implied consent plays a significant role in the process of DWI investigations in New York. It covers everything from the moment an officer suspects a driver may be impaired to the administration of chemical tests. Let's look at this process in detail. Traffic stops and suspicion of DWI. A DWI investigation typically begins with a traffic stop. Law enforcement officers might pull a vehicle over for a variety of reasons. It could be for a minor traffic violation, erratic driving behavior, or a routine DWI checkpoint. Standardized field sobriety tests. If an officer suspects that a driver is impaired, they may ask the driver to perform field sobriety tests. Types of chemical tests. If an officer has reasonable grounds to believe a driver is impaired, they can request the driver to submit to a chemical test under the implied consent law. The role of implied consent in breathalyzer tests. Under New York's implied consent law, if an officer requests a breathalyzer test, a type of chemical test, the driver is expected to comply. Consequences for refusing a chemical test under implied consent. While the implied consent law in New York does require drivers to submit to chemical testing when lawfully arrested for suspected drunk driving, you do have the right to refuse these tests. However, refusal comes with serious consequences that can have a lasting impact on your driving privileges. In New York, if you refuse to take a chemical test, breath, blood, urine, or saliva, your driver's license can be immediately suspended. This suspension is automatic and happens right at the moment of your refusal. The officer will confiscate your driver's license and issue a temporary driving permit that's valid until your hearing on the refusal. Following a refusal hearing at the DMV, your ability to gain a conditional license can be revoked if the suspension is upheld. The duration of the suspension of your driving privileges depends on your history of refusals and convictions for drunk driving. For a first-time refusal, your license will be revoked for at least 1 year and you may be required to pay a $500 fine. If you've refused a chemical test before, or if you've been convicted of a DWI, DUI in the past 5 years, the revocation period increases to at least 18 months with a fine of $750. The chemical tests under implied consent. Following an arrest for suspected DUI, DWI in New York, law enforcement may administer several types of chemical tests to determine the level of alcohol or drugs in your system. This falls under the purview of the implied consent law. Here's what you should know about these tests. Breath test. A breath test, often administered using a device known as a breathalyzer, is the most common type of test used in DUI, DWI investigations. Blood test. A blood test provides the most accurate measurement of the amount of alcohol or drugs in the driver's system. Urine test. A urine test may be used to detect the presence of alcohol and drugs in a driver's system. Limited grounds to refuse chemical testing. While the implied consent law in New York generally requires drivers to submit to chemical testing when lawfully arrested for a DWI, there are very limited grounds under which a driver can refuse such a test without facing penalties. Here, we will cover these exceptions. Medical inability to take the test. In some cases, a medical condition may prevent a driver from being able to take a certain type of chemical test. No Miranda constitutional rights to refuse. Contrary to what some people believe, there is no constitutional or Miranda right to refuse a chemical test under the Implied Consent Law. Confusion about consent is not grounds. Another common misconception is that a driver can refuse a test because they were confused or did not understand what was being asked of them, requesting an additional chemical test. In some cases, after law enforcement has administered a chemical test, a driver may wish to have an additional test performed. This can be an important part of building a defense in a DWI case. Here's what you should know. Right to additional test at own expense. In New York, if you have been arrested for a DWI and have undergone a chemical test administered by law enforcement, you have the right to request an additional independent test. Must be done promptly after initial test. If you choose to have an additional test performed, it's important to understand that this test must be done promptly after the initial test. Results can be used to challenge initial test. The results of an independent test can be used in court to challenge the accuracy of the initial test performed by law enforcement. Hearings and suspension appeals related to chemical test refusal. If your license has been suspended due to refusing a chemical test under New York's Implied Consent Law, there are specific procedures to challenge this suspension. It's important to understand these steps, as well as the limited grounds on which an appeal can be made. Hearings to challenge license suspension. After a refusal to submit to a chemical test, a hearing will be scheduled in the DMV. Limited grounds for appeal. The grounds on which you can appeal a suspension for refusing a chemical test are limited. Procedures and time limits. It's crucial to act promptly when seeking to challenge a license suspension for refusing a chemical test. In New York. Other consequences of refusing a chemical test. Refusing a chemical test in New York under the Implied Consent Law can have significant consequences beyond immediate license suspension. The refusal can impact your DWI case and potentially lead to increased charges or penalties. Here's a closer look at these consequences. Refusal can be used as evidence in DWI case. If you refuse a chemical test, that refusal can be used as evidence against you in a DWI case. Possibility of increased charges, penalties. In addition to being used as evidence against you, a refusal can also lead to increased charges or penalties. How an experienced Long Island DWI attorney can help. A skilled Long Island DWI attorney can play a crucial role in helping individuals charged with a DWI understand the nuances of the Implied Consent Law in New York. Here are some key ways an attorney can assist. Clarifying legal rights and procedures. A skilled attorney can provide clear explanations about an individual's rights under the Implied Consent Law, the procedures involved, and the potential consequences of refusing a chemical test. Formulating a defense strategy. If a client has refused a chemical test, a seasoned DWI attorney can help them understand the potential legal repercussions and assist in formulating a defense strategy that considers this refusal. Preparing for refusal hearings. A skilled attorney can help ensure clients are prepared for hearings related to license suspensions following a chemical test refusal. Assisting with appeals. If the initial hearing does not go favorably, an attorney can assist with the appeal process. Call top-rated Long Island DWI attorney Jason Bassett today. If you or a loved one has been charged with a DWI on Long Island, New York, and are facing legal issues regarding the Implied Consent Law, seek legal guidance from a seasoned professional. Jason Bassett, a top-rated Long Island DWI attorney, is here to provide the experienced legal advice and representation that you need. With extensive knowledge and experience in New York DWI law, Attorney Bassett can help you understand your rights, the charges against you, and the complexities of the Implied Consent Law. He can provide crucial guidance, build a strong defense strategy tailored to your unique circumstances, and stand by your side throughout the entire legal process. The consequences of a DWI charge can be severe, but with the right legal support, you can fight for the best possible outcome. Contact the law offices of Jason Bassett, PC today at 631-259-6060 to schedule a consultation and take the first step towards protecting your rights and building a robust defense. Your peace of mind and future depend on it.